of the husband's violation as several violations of financial provisions of the marital dissolution agreement. Ultimately, the trial court found that the wife had failed to rebut the statutory presumption and awarded the husband a retroactive modification of the alimony and a judgment for $24,000. However, the trial court also found that the wife had prevailed on 2 counts of her contempt in her petition against husband and dismissed a third, awarding her a portion of her attorney's fees. We are asking on appeal for this court to reverse the trial court's decisions as regards the alimony petition. And the meat and potatoes of our case is the analysis of this colloquial cohabitation clause of the statutory provision for transitional alimony. That statute is, in essence, a 4-step process. And you begin first with determining whether the alimony recipient is living with a third party. We stipulated to that fact at trial that the appellant was indeed living with her boyfriend. And so that triggered the rebuttable presumption to be raised. That takes us to this next step of the analysis as to whether the alimony recipient was contributing support to or receiving support from this third party. This court has analyzed this issue in detail before. The seminal case on transitional alimony modification is, in my opinion, Scherzer versus Scherzer. And it really supports the premise that if you show that you are equally dividing household shared expenses with this third party, then you are able to rebut this component of the statutory presumption. In that case, in the Scherzer case, the wife was living with her fiance. They had purchased a residence together, and she came into court stating that they were dividing everything equally, 50-50. However, this court affirmed or stated over and over in the opinion that there was no corroborating evidence to support her assertion that it was 50-50, and stated because she was unable to show this evidence that she had failed to rebut the presumption, and that actually, in reality, she was the one shouldering all of the expenses and thus supporting the third party through her alimony. That same premise of 50-50, if you're able to demonstrate that, was again reiterated in another case called the Winnie case in 2019. Similar, where the recipient was living with a boyfriend. They had purchased a house together. She walked into court stating that they were dividing everything equally, but there was no evidence to support that whatsoever. And this court said that the wife had failed to even quantify what her half of this 50-50 entailed. In this case, there is so much proof in the record. It is replete with exhibit after exhibit to show that the appellant and her boyfriend that were living together were very intentional as regards the division of these household shared expenses. And the trial court agreed and found that they were jointly had an account where they deposited equal sums into this bank account to pay these shared expenses for the rent, the utilities, and other household bills. However, all the rest or remainder of the appellant's expenses for herself and for the benefit of the minor child was paid through her separate account, through her alimony and her child support. It was not paid through the boyfriend or through the joint account whatsoever. Same thing, he had his own separate account where he paid his separate expenses. And so the trial court understood these facts, recognized these facts, but still reached the conclusion that the appellant had failed to rebut the presumption, arguing that this nonetheless resulted in a contribution of support, in a sense stating that they benefited from the whole by only paying half. And my argument to that is it would render the statute entirely useless, because you only when you're living with a third party, there's naturally only 3 options. You're either one, the recipient is paying for more of the expenses, thereby contributing to the support of the third party. That's what occurred in the Scherzer case. Or the third party is paying for more of the expenses on behalf of the alimony recipient, which is what occurred in Winnie. or they're equally dividing the expenses. And so our argument as to this component of the statutory presumption is that the appellant certainly rebutted it through the proof that they were equally dividing these expenses, because otherwise to state that an equal division is nonetheless contribution would render the statute useless. But even if an alimony recipient fails to overcome that part of the statute, all is not lost, because you continue on to the next step of the analysis, which is whether there is a continuing need, whether the recipient can prove a deficit of funds despite the cohabitation. And in this case, the recipient, the appellant, proved exactly such. She introduced into evidence her income and expense statement that showed a large deficit of funds. The trial court's findings of facts recognized that, stating that she was having to consume cash from the distribution of the marital estate that she received in order to make up her expenses each month. He recognized that her lifestyle, the expenses of her lifestyle, were not met. And that in and of itself shows that she has a continuing need for the alimony. However, the trial court made interesting conclusions that she no longer needed the alimony because she had failed to obtain employment following divorce. She was not employed at the time of divorce. She had not been employed as a massage therapist, which is what the trial court suggested she should obtain employment as, for 15 years. She was not qualified to work in Tennessee. The record shows that she had only had a license in Texas. And especially given this trial was occurring at the height of COVID when it first occurred, we're still having in Zoom meetings for court hearings, that it's a little difficult to assume that she would have been able to obtain employment, and thus she needs to lose her alimony as a result. Finally, the trial court had stated and argued that she no longer needed transitional alimony because she was in a domestic partnership with her boyfriend. My argument to that is that someone's relationship has no bearing as to whether there is a financial need. At the time of divorce, you're restored to the rights and privileges of an unmarried person. And I have cited several cases in my brief where an alimony recipient who was in a relationship or even married was able to rebut the presumption that she still needed alimony due to a deficit of funds. And so it's not an appropriate ground to suspend a party's alimony on the basis of her relationship status. So while I'm confident the court will reverse the trial court's opinion on the fact that we do feel we rebutted the presumption and that the evidence supports such, in the event the trial court does uphold, or this court upholds the trial court, we state that the trial court did not have authority to award a retroactive modification of the alimony. Opposing counsel has stated in his brief several child support actions where retroactive relief is provided, and that is true because in child support statutory scheme, it is modification retroactively is expressly provided. That is not the case in the alimony statutes. It's silent as to retroactive modification. And the case that the trial court cited to as a basis to award this retroactive relief was a case that used this language that in order to apply an alimony reduction retroactively, there must be a specific written finding by the court that the obligor's inability to pay was through no fault of his own, and that a retroactive modification should be made in order to meet ends of justice. This language was reflective of the former, in the 1980s, I believe it was 1985 statute of alimony in Tennessee. It's no longer present in the statute whatsoever. And so my argument is that where we have the express language in child support, it's silent in the alimony provisions now, but we used to have language regarding it, tells me that there is no authority for a trial court to award retroactive relief, and would state that it's an injustice in this situation regardless. The husband was, according to the trial court, persistently tardy in his alimony payments each month, resorted to self-help. He was in contempt of court, and we argue it's an injustice to the appellant to ask to award this retroactive judgment to him when he continuously disregarded a court order. As regards, I'll go quickly to the civil contempt issue. We do not disturb the two findings of contempt on appeal. The one contempt action we have an issue with is regarding the dismissal of the certificate of deposit. The trial court had stated that we had failed to prove damages and thus dismissed the contempt action. What we had been asking for was prejudgment interest, because that in effect is to satisfy a party who has been inherently damaged. My client went 6 months with having her funds withheld from her against her will by the husband, and the contempt action was dismissed, stating that we hadn't pled damages because the husband had purged his contempt prior to the final hearing. Again, we state her damage was inherent, that she was refused access to her cash for 6 months, and she had to incur attorney's fees in order to compel his compliance. And I believe I'm out of time. Thank you so much.
One question.
Yes.
In your case, the ex-wife was renting the unit before the third party moved in. And so she was paying the entire amount of the rent and also all of the utilities. So to the extent that someone moves in and then pays 1/2 of all of that, is that contributing to the ex-wife support?
It's a very good question. Prior to the third party moving in, yes, she was paying for everything. She was also receiving up to $9,000 a month because her alimony had not begun yet. She was still receiving the contributions from the corporate distributions from the family business. And so when the buyout of the business occurred and she received her lump sum is when the distribution ceased. She started her alimony the next month. And then several weeks later, the third party moved in. So at the time, she was able to financially afford everything because she was getting up to $9,000 a month from the distributions plus the child support.
Okay, thank you, Ms. Altshuler.
Thank you.
Mr. Shell.
Good afternoon to the court. I'm Edward Shell, a member of the Williamson County Bar here on behalf of Patrick Strickland. As far as the alimony issue is concerned, it's clear that these parties agreed that it would be modifiable in the event of wife's cohabitation with her romantic partner, and that's exactly what happened. She had this gentleman moved in the very month that my client's first alimony payment was due. And I think the trial court properly found actually much of wife's proof went to prove that she does not need the alimony any longer, as opposed to overcoming the presumption. She testified on cross-examination, as Judge Armstrong just mentioned, that prior to the time Dr. Pinyard moved in with her, she was solely responsible for paying all of the living expenses associated with this apartment, and that at the time of trial, she was not, because she was getting a contribution from him. And she also admitted that before Dr. Pinyard moved in with her, he had an apartment of his own where he was solely responsible for the payment of those expenses. And he doesn't have that now because he's living with her. And as I argued to the trial court, I think what these folks are losing sight of, or Ms. Living is losing sight of, is they claim that they're contributing equally, but they're both enjoying the whole. So Ms. Living is not enjoying the use of half an apartment or half of the utilities. she's benefiting from the entire thing because of the contribution made by Dr. Pinyard. And Judge Woodruff also noted, Ms. Living testified based on her income and expense statement that she had to draw money down from the division of marital assets to pay her living expenses, and they were getting paid.
But we can't say that she is supporting this third party, and we can't say the third party is supporting her either. It's sort of a mutually beneficial thing, right?
Well, I think that they're both supporting each other to the extent that each's lifestyle is better than what it would be if they weren't together.
Well, isn't that always the case when people cohabit? I mean, is that one of the reasons we cohabit?
Yeah, I think it probably is the case.
Then-
But in context of the alimony statute, you're not entitled to
How would you
continue
ever
getting it.
defeat the presumption? How would you ever defeat the presumption then? In
I
that,
suppose you would have to clearly show that you weren't getting, that no one else was getting the benefit of your payments for living expenses, and that you weren't getting the benefit of them from anybody else.
how is that possible when you cohabit and pay some percentage of the?
Well, there wasn't any proof that they paid an equal percentage. I think what the proof showed is that they established a joint checking account, and Ms. Living was depositing her alimony check and her child support check into that account, and that's what was being used to pay living expenses. And she further testified that if not for the contribution from Dr. Pinyard, she would be drawing down even more of her assets that she got as property division than what she was. So I think to that extent, she's clearly benefiting from these contributions to him. And within the context of transitional alimony, I think the intent was that the obligor would no longer be required to financially support that kind of a lifestyle choice. Judge Woodruff essentially found here that the entire reason for transitional alimony had been frustrated here, because this lady never even attempted to make the transition from married life to single life. She went from married life to having a live-in boyfriend who was sharing expenses with her. And she would not work. She had a history of working, but would not work. And that too contributed to the fact that she was having to draw down these assets, and that she was having to rely on what Dr. Pinyard paid her, or paid for those expenses. I don't think the Scherzer case stands for the proposition that Ms. Altshuler has argued. The most striking difference is in the Scherzer case, there was no provision in the MDA that the transitional alimony could be modified upon the wife's cohabitation with a romantic partner, and that's clearly the case here. With respect to the court's decision on attorney's fees and how that was divided up, the only claim for relief that my client had before the court was the suspension of the alimony payments, and he won on that point. And for that reason, the court awarded my fees, which were never challenged. Then the court looked at the causes of action on which Ms. Living had prevailed and found that there were only two out of the ones that she had filed, and that was related to whether she was entitled to additional damages for not getting the CD on time, and then also whether she had incurred damages because she had to pay penalty and interest to the IRS. And she prevailed on those issues, and the court did an analysis of how much it thought the attorney's fees should be attributed to that. And the court found that the vast majority of the time that Ms. Living's counsel spent working on this case was in unsuccessfully defending my client's petition regarding the transitional alimony. So I think he reached the right result in that regard. With respect to the CD that Ms. Altshuler referred to, the proof was uncontradicted that Ms. Living got exactly what my client got, and that was half of the face amount of the CD, along with all the interest that had accrued up until the date that she got it. And there's nothing in the record to indicate how she could have earned more money or could have invested this money in a different way. I mean, she got what she was supposed to get when it came to that. And the court found that my client was responsible for the tax liability, the penalty and interest that she incurred, and gave her a judgment accordingly for that. And then after the offset was done, it was left with her owing my client just a little bit of money. So in summary, I believe that the court properly found that she failed to rebut the statutory presumption. And I think the court was correct in the way it allocated responsibility for the attorney's fees. Unless the court has questions, I'll rely on my brief.
Okay. Thank you, Mr. Shell.
Very well. Thank you all.
Ms. Altshuler.
Thank you so much. And Judge Bennett, I would say your questions to Mr. Shell are exactly my argument on appeal. That sharing expenses rebuts the presumption. It's what the case law demonstrates. It's what happened in Scherzer and in Winnie. They said if there had been corroborating proof, they would have been able to overcome the statute. Because if you're equally dividing these expenses, neither person is supporting the other. And to go back to Judge Armstrong's previous question, I will state again that she was receiving up to $9,000 before the boyfriend moved in. When the alimony started, she was reduced down to $2,000 a month in alimony. So that was why she was having to consume so much of her cash to pay the expenses. I would like to dispute some of the factual statements that Mr. Shell had made. She did not deposit her alimony and child support into the joint account. That's in the record. She deposits that into a separate account. In the joint account, yes, they both put money. That's her money's been commingled with all of her cash from the division. So she will make equal withdrawals to the joint account. Her boyfriend makes the exact same contributions to that joint account to pay the joint expenses, but she does not deposit her alimony into the joint account. I would urge the court to look at exhibits 7 through 11 of the record. This will show you the financials of the situation that shows what expenses are being paid equally from the joint account, with the proof down to the penny of every single expense that was spent over the past year equally. Also shows to the penny all of her separate expenses that are paid from her separate account. And also goes to show that the mortgage and the utilities are all being paid equally. Those checks, deposits, everything. It's in the record for the exhibits. Just quickly too about the attorney's fees, what the trial court had stated was that it was almost a wash in terms of Mr. Shell had prevailed on his petition as regards the transitional alimony. We had prevailed on contempt and so in that sense, his exact language was, to the extent both parties rely on the fee shifting provision of the NDA, neither is entitled to relief. We were awarded $3,100 of attorney's fees as a means of damages for the contempt action. We are stating that it was improper to dismiss the third contempt about the certificate of deposit, again, because of the inherent damage of being denied her cash for 6 months, and that should have been used as an additional grounds for more attorney's fees at the trial court level. Thank you so much.
Thank you. Thank you both. We appreciate your arguments.
Thank you all.
Ms. Lindsay, would you please recess court?
This Honorable Court of Appeals stands adjourned.
You can sign out now.
Thank you.
You're welcome.